So that any property they seized at the time, they include that, and if you don't have any ownership interest in it, then it's irrelevant towards you.
Exactly.
But there is some money and phones apparently as well.
No, they never took my phone. They never took my phone. I got that.
Well, then why
I
is
kept
the
my
phone
phone. They
listed
never
in
took
there?
my phone.
You said they took it. It's
No,
a
they-
phone that
They never took my phone. Never. I
they
got my
used for all
phone.
3 buys, the cell phone that they recovered from him.
Never took my phone.
Did they ever take
I don't
There's
know.
nothing to
No.
forfeit
No,
then.
right, right. I
What
got
about
my
money?
phone.
Let's try 3 for 3.
Yeah.
All right, so you'll be forfeiting that at the time, you understand that?
Yes, sir.
All right.
They never took my phone.
Excuse me. And Mr. Askew, you were able to hear what the prosecutor just had to say regarding what he believes your intentions are here this morning?
Yes, sir.
He indicated to this court he believes it's your desire to withdraw your previously entered pleas of not guilty and plead guilty to 3 counts of this indictment, counts 1, 4, and 5, and I'll go over those with you to make sure you understand them. The remaining counts would get dismissed. We would defer sentencing to a later day to get some evaluations completed, come back on a future date for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do here today?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you had that you give up by pleading guilty, as well as all the possible penalties that you face. So for me to determine those issues, I will ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right? You have to say yes or no for the court.
Yes, sir.
Thank you. All right, well, let's get started then. How old are you, sir?
54.
I'm sorry?
54.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, before you came into court here today, have you any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
No,
Not
sir.
even prescribed medication, nothing?
No, sir.
Now, you should have received a copy of this indictment. Looks like you got it sometime maybe about the middle of April this year. That's the document that sets forth the specific charges you're accused of committing. Do you remember getting that at some point?
Yes, sir.
And did you have a chance to look that over?
Yes, sir.
Now, in that indictment, you're charged with 6 separate offenses. You're pleading guilty to 3 of those, so I'm going to go over those 3 charges with you. Again, if you have any questions, make sure you ask. But in count 1, what's alleged here and what you're admitting to is on or about November 25th, 2024, in Fairport Village, Lake County, Ohio, that you didn't only sell or offer to sell cocaine or some compound mixture, preparation, or substance containing cocaine. The amount involved did not equal or exceed 5 grams, was 0.47 grams, which makes the offense trafficking cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes, sir.
Any questions about it?
No, sir.
Now, count 4, so next count you're pleading guilty to. What's alleged here and what you're admitting to is on or about December 20th, 2024 in Fairport Harbor Village, Lake County, Ohio, that you did knowingly possess or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount involved equal or exceeded 5 grams, but was less than 10 grams. It was 8.49 grams, which makes the offense possession of cocaine a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in count 4?
Yes, sir.
Any questions about that?
No, sir.
Now, in count 5, what's alleged here is on or about December 20th, 2024 in Fairport Harbor Village, Lake County, Ohio, that you, not having been relieved from disability under operation of law or by legal process, that you knowingly acquired, had, carried, or used a firearm or dangerous ordinance, and that you were under indictment for or previously been convicted of a felony offense involving the illegal possession, use, sale, administration, distribution, or trafficking in a drug of abuse, that being possession of cocaine, and here in the Lake County Common Pleas Court back on October 20th of 2009. That conduct constitutes the offense of having weapons while under disability. It's a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in regards to count 5?
Yes, sir.
Any questions about that for me?
No.
So you understand the nature of the 3 charges you're pleading guilty to?
Yes, sir.
Now, there are 3 other counts in this indictment. Those are all being dismissed pursuant to the agreement reached by your lawyer with the prosecutor. Is that your understanding?
Yes, sir.
Do you have any questions about those 3 charges that you'd like to ask?
No, sir.
Well, then before I can accept your plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, have the right to have a trial in this case. Now, the trial could be to me as a judge, where I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial could be in front of, or would be in front of, 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those 12 jurors would consider and weigh all that evidence. Then those jurors will make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision. What that means is all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, sir.
Now, if we did have a trial, you'd have the right to have an attorney represent you at that trial. And if you cannot afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, sir.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. With him having the burden of proof, what that actually means is that it's his job, or he bears the responsibility, the obligation to prove you guilty at a trial before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when I speak of this burden of proof, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden of proof we have in our justice system. What it means, it's the amount of the evidence and the quality of that evidence that the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or part of these charges beyond any reasonable doubt before you could ever be found guilty at a trial of any of these charges. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
Now, in order to try to do that, if we're going to have a trial in this case, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. And we call that cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here to testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come into court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, sir.
And you further can request this court issue an order and call that order a subpoena. What a subpoena would do is it would force or make someone come to court to testify for you and answer your lawyer's questions if anyone was not willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision, that's a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's solely your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, he's not allowed to call you as a witness and make you get up on the stand and testify and answer questions. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
You further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Do you understand a guilty plea is a complete admission of guilt? That means you're admitting to the facts that are being alleged here by the prosecutor. We're not going to argue that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you're pleading guilty to 3 charges here. Count 1 is a felony of the 5th degree. That's the trafficking cocaine charge. That carries with it a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes, sir.
Now, count 4 is the next count you're pleading guilty to. Possession of cocaine is a felony of the 4th degree. This carries with it a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, sir.
Lastly, count 5, the weapons under disability charge is a felony of the 3rd degree. That carries with it a possible term in prison of a minimum of 9 months, a maximum of 36 months, or certain increments in between of either 12, 18, 24, or 30 months. So if I impose the prison term in that count, I'd select one of those numbers, 9, 12, 18, 24, 30, or 36, and that'd be the number of months in prison you have to serve for that count. Do you understand that?
Yes, sir.
Now, since we have 3 separate charges here, if I imposed a prison sentence, I impose it on each count, and then as a judge, I have the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means you'd serve those counts at the same time, together at the same time. Consecutive means you'd serve those counts one after the other. You'd serve the prison term on the first count, complete it, then the next count, etc., for whatever counts are consecutive. Do you understand that?
Yes, sir.
So in this particular case, if I imposed a maximum sentence on each count and ran them all consecutive, you're looking at a maximum possible prison term in this case of 66 months or 5.5 years in prison. Do you understand that?
Yes.
Now, are you currently on probation or parole to any other courts or agencies?
No.
Do you have any other charges pending against you anywhere?
No.
If a prison sentence were imposed in this case at any point, upon your release from prison, you could be placed on what we do call post-release control. We sometimes call that parole. It's a period of supervision you'll be on after you served and completed whatever the prison sentence was. And in this particular case, it could be up to 2 years. Do you understand that?
Mm-hmm. Yep.
And if you are on post-release control and have violated any of the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. Strike that, I jumped ahead. If you were on post-release control and you ever violated their rules, the parole authority would have a hearing and they could send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term is imposed by the court. Do you understand that?
Yes.
Now, aside from the possible prison sentence that I just mentioned, there's other sanctions that could be ordered. You could be fined in this case. Count 1, the trafficking charge carries with it a possible fine of $2,500. Count 4, the possession of cocaine charge carries with it a possible fine of $5,000. And the weapons charge in count 5 carries with it a possible fine of up to $10,000. So altogether, there's a maximum fine of $17,500. Do you understand that?
Yes, sir.
You could also be ordered to pay court costs or reimburse the county for any costs of confinement, community supervision, or treatment if any that were applicable. Do you understand that?
Yes, sir.
I also have the discretion, it's not mandatory or required, but I could suspend your driver's license up to 5 years. Do you understand that?
Yes, sir.
And the paperwork shows there's a voluntary forfeiture of not just the drugs, but some money and phones. Is that correct?
In firearms, yes, Your Honor.
Is that accurate?
That is accurate, yes, Your Honor.
And you'll be agreeing on sentencing to forfeit those items, Mr. Askew?
When forfeiture with firearm, I never had it. It's not my gun. So.
Right.
Well, the
Right.
way that works, I'm sorry, any right, title, or interest you have in the firearm. If you don't have any, then there's nothing for you to forfeit. But if you do have any ownership interest in it, it would be forfeited.
No.
Well, I'm just telling you that's what that means.
Yeah, do you agree?
So that any property they seized at the time, they include that, and if you don't have any ownership interest in it, then it's irrelevant towards you.
Exactly.
But there is some money and phones apparently as well.
No, they never took my phone. They never took my phone. I got them that.
Well, then why
I
is
kept
the
my
phone
phone. I
listed
never
on
took
there?
my phone.
You said they took it. It's
No,
a
they-
phone that
They never took my phone. Never. I
they
got my
used for all
phone.
3 buys, the cell phone that they recovered from him.
Never took my phone.
Did they ever take
I don't
There's
know.
nothing to
No.
forfeit
They
then.
never took- Right, right. I
What
got
about
my
money?
phone.
Let's try 3 for 3.
Yeah.
All right, so you'll be forfeiting that at the time, you understand that?
Yes, sir.
All right.
I never took my phone. Right.
All good?
Yes, Your Honor.
All right, Mr. Askew, now, so, a few moments ago I explained the possible prison sentence you face. I did use the word possible, however, prison is not mandatory with these charges. You are eligible for probation, or what we formally call community control sanctions. Do you understand that?
Yes, sir.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're asking for. I'll look at all the information that gets presented, then I'll make the decision that I ultimately think is the right thing to do. Do you understand that?
Yes, sir.
Now, if you are put on community control sanctions, it could be for up to 5 years. And as the judge, I do have the discretion to order a wide variety of rules or conditions for you to follow. One of those conditions could be an order that you serve a term in our Lake County Jail of up to 6 months as a condition of probation. So even if you were to get probation, you could still get local incarceration. That's not mandatory either, but it could be ordered up to 6 months in the county jail. Do you understand that?
Yes, sir.
And if you are put on probation at any point and you ever violate any of the conditions of your probation, we would have a hearing here in court to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it was not initially 5 years. I could impose more restrictive sanctions against you, which could include an order that you serve time in our county jail. Or I could at that point terminate or end your probation and send you to prison then. And again, that could be ultimately up to a maximum of 5.5 years. Do you understand that?
Yes, sir.
Lastly, when we do come back here for sentencing, you're going to have the right on that day to say anything you want, anything you'd like me to know or consider. Your lawyer could speak on your behalf. He's allowed to recommend a sentence to the court. The prosecutor is also allowed to recommend a sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever the lawyers say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I don't have to follow that if I didn't think that's the right thing to do. Do you understand that?
Yes, sir.
All right. Well, do you have any questions at all then regarding the potential penalties you face by pleading guilty?
Yes, sir.
You understand everything that could possibly happen at sentencing?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to talk about the case with your lawyer and have him go over the reports with you, discuss whatever issues there may be, and they answer any questions you may have?
Yes, sir.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
Yes, sir.
All right, then do you have any questions for me at this time regarding anything we've talked about, the penalties you face, what you're pleading guilty to, the rights you're giving up? Any questions at all?
No, sir.
Do you need any more time to talk with your lawyer before we go forward with the actual plea of guilty?
No, sir.
Okay. So what's going to happen at this point is that the prosecutor here is going to explain for me what he believes the evidence would show if we had a trial. I want you to listen to him because I have some questions for you about that, all right? So, Mr. Geigerich?
Thank you, Your Honor. The evidence would show that the defendant was targeted by Lake County Narcotics with a confidential informant. On November 25th, 2024, a deal was set between the CI and the defendant for $50 for crack cocaine. The deal was to occur at 313 7th Street in Fairport Harbor, Lake County, Ohio, which was the defendant's residence. The deal did in fact occur. The suspected narcotics were sent to the Lake County Crime Lab where it tested positive for cocaine, an amount of 0.47 grams. After 2 other controlled buys at the residence, a search warrant was executed at the 313 7th Street Fairport Harbor residence on December 20th, 2024. Off the defendant's person, they recovered a cell phone that was used for all 3 buys, $104 in U.S. currency in his right pocket, and suspected powder cocaine in his right jacket pocket. And inside the residence, they found a pill bottle with 2 baggies with white powder in the dresser bedroom 1, a baggie with white powder in the nightstand, $770 in U.S. currency in the dresser bedroom 1, a Beretta 9mm pistol, a high-point pistol, and a Smith & Wesson .38 revolver were recovered from the living room dressers and the bedroom dresser, and a jar with suspected lidocaine was in bedroom 2 in a box. The defendant stated he knew the firearms were in the house and he admits he deals with people he uses with. He is correct. They gave the phone back to the defendant after his contacts were photographed because he claimed it was his work phone. The defendant had previously been convicted possession of cocaine, Lake County Common Police Court of 08 CR 661 for possession of cocaine. He was convicted on October 20th, 2009, which would prohibit him from having a firearm. Thank you, Your Honor.
Now, so let's make sure we're on the same page, that they returned the phone, so it's not being part of the voluntary
No, it
forfeiture.
is not.
then.
And the cocaine that they recovered from the residence was 8.49 grams after being sent to the Lake County Crime Lab. Thank you.
Mr. Askew, were you able to hear what the prosecutor just had to say regarding what he believes the facts would show if we had a trial?
Yes, sir.
And what, if anything, do you have to say about those facts as he presented them regarding those 3 counts? Are they true? Did you do what he said?
Yes.
Very well, then, regarding count 1, charging with trafficking cocaine and felony the 5th degree, what is your plea at this time?
Guilty.
Regarding count 4, we're charging with possession of cocaine and felony the 4th degree, what is your plea to that count?
Guilty.
And regarding count 5, charging with having weapons while under disability of felony the 3rd degree, what is your plea to that count?
Guilty.
All right, I have in my possession at this time a 4-page document. It's called a written plea of guilty and judgment entry, which explains everything we've just gone over. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over this with your lawyer. Is that correct?
Yes, sir.
Mr. Kuharski, is that accurate? Did you read this over with Mr. Askew, review it with him, answer any questions he has?
I have, Your Honor, yes.
In doing so, did he indicate an understanding of it to you?
He did.
Is that correct, Mr. Askew?
Yes, sir.
So you understand what this document says?
Yes, sir.
You have any questions for me about it?
No, sir.
It also appears on the last page, at the top of that last page, you signed the document. Did you in fact sign it?
Yes.
Mr. Kuharski, excuse me, you witnessed that?
I did.
Mr. Geiger, you as well?
I did, Your Honor.
Very well then, at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, trafficking cocaine, a felony of the 5th degree, violation of 2925.03A1. Count 4, possession of cocaine, a felony of the 4th degree, in violation of 2925.11. And count 5, having weapons while under disability, a felony of the 3rd degree, in violation of 2923.13A3. The remaining counts will all get dismissed. I'll defer sentencing. Order a pre-sentence report and investigation. Are you requesting any other evaluations? Did you want a drug and alcohol evaluation, or is that
Yes, Your Honor.
a drug and alcohol evaluation? And I will continue your bond. That is at $7,500 cash surety or 10%. So what all this means, Mr. Askew, as far as bond goes, I'm continuing the bond that's been posted. Nothing more you need to do at this point. You need to follow the conditions of your bond, which have been in place since the beginning here. One of those is that you don't use any drugs while you're on bond. You have to submit urine screens if requested. Those must be negative. A positive screen will result in your bond being revoked and a warrant being issued for your arrest. Now, the purpose of these reports is so that I can learn more about you before sentencing. And the way the probation department will go about getting that information is they're going to conduct some interviews with you. It's important, first of all, that you show up when you're supposed to for those interviews, because they can't conduct the interview because you didn't cooperate or you didn't show up, then they can't complete a report. Without a report, the law doesn't even allow me to consider probation as an option. You understand that?
Yes, sir.
It's also important that you be open and honest with them, because they're going to check and verify everything you tell them. If they learn you're misleading them in any way, they'll let me know that, and I would consider that at sentencing. Do you understand that?
Yes, sir.
All right, so you're going to leave here now. You're going to go over to the probation department, fill out some initial paperwork, and get the dates to come back for those appointments. So make sure you do that when you leave here, all right?
Yes, sir.
Mr. Geiger?
Your Honor, you're dismissing the charges now?
I thought I said I said it's sentencing, but I'm deferring sentencing.
You're right, and then you said the remaining charges are dismissed. That's why I was curious.
I thought I said they'd be dismissed at sentencing, but
Okay.
sentencing is deferred. No, they'll be dismissed at sentencing.
All right.